The morning docket of the Orange County Municipal Court. First group of cases we're going to call are review hearings. When you hear your name called, come down to the table on my left, your right, and we will review your case.
Eric Childers, Aaron Davis, Michael Johnson, Jared Meredith, Charles Ritchie, Michael Rowe.
Garrett Childers?
Yes, sir.
All right, State of Ohio versus Garrett Childers, CRB 24221. All right, Mr. Childers, doesn't look like you've done any new community service. Still got 18 hours.
I do have an update on that. I just got my new truck. I can start on that pretty soon.
How soon?
Maybe this coming week. I can probably call one of these days here soon, double check. What is it again, 7:30 when it starts?
Yes.
7:30. All right, I'll set you a new review hearing. May the 4th.
May
At
4th?
9 a.m.
All right.
Aaron Davis,
Yes, sir.
State of Ohio versus Aaron Davis, PRC 2369 A&P. And looks like you've got all your community service done, Mr. Davis. You just have fines left.
That's
You
it.
can work some of that off on community service if you wish.
I've been out of state. I just drove all the way back from Wisconsin to come, so I have the money to pay it off.
Okay, so you're planning on paying it off today?
Yeah.
All right, here's what I'm going to do. I will set you a review for May the 4th in case there's something remaining.
Okay.
But once that's paid, that review hearing will be canceled.
Oh, so, okay, I didn't know about the driving class or something I had to do 3 days for or something to do. They said something I have to go somewhere.
You got to do a 3-day driver intervention program. Have you not done that yet?
No, because like I said, I got to go right back to Wisconsin. I came down here, flew in for long story short, I won't be done till work till the end of May. So that's
Why don't I do this then? Since you've acted quickly and that'll be all you've got left, I'm going to change that review hearing to August 24th.
okay. That'll be all done by then.
And then once you've paid that and submitted that your 3-day driver program, that
Okay.
hearing will be canceled.
Okay, thank you.
All right, thank you. Michael Johnson. All right, this is State of Ohio versus Michael Johnson, CRB 24323. Looks like I see you've got a completion certificate for your outpatient services, Mr. Johnson. Looks like you were ordered to do some community service before being here. Doesn't look like that's occurred.
I have been doing community service. He allows me to do them in Portsmouth. I just didn't know I had to bring a paper from Portsmouth.
Your Honor, if I may, he did come speak to us this morning, and he did say he has done some. I told him I needed proof of it. I do not have proof of it.
Okay. Well, Mr. Johnson, you've come a long way, and so I'll give you some grace.
I'll bring it next time I come in.
I'm going to set you back for May the 4th at 9 a.m. for review. All the fines are paid, all you have left is community service.
Yeah.
All right, thank you. Jared Meredith? You may vote. All right, this is State of Ohio versus Jared Meredith, CRB 2462, TRD 221036, CRB 2263, and TRD 22920. Excuse me, and CRB 19756, CRB 19780. All right, Mr. Meredith, good report. While you're treating, I'm a little less concerned about getting the cases done as I am making sure you're getting your treatment. Set you back May the 4th for review at 9 a.m. Thank you. Charles Ritchie. To the State of Ohio versus Charles Ritchie, CRB 25-766A and B, CRB 25-662, CRB 25-165.
Treatment.
Your Honor, he does have some community service to turn in.
Okay.
Your Honor, that's not to prove the community service. He has done some community service. I do know that for a fact. That's not the paperwork. He'll get it to me.
Okay. Now, do we have a treatment report?
He's at TPC Wellness up in Mount Orb.
Mount Orb.
Okay.
And
How are things going?
going well. He's participating in all of his groups and doing everything that he's being asked to do.
Okay. Based on that report, I'll set you back for May 4th, 9 a.m. for review.
I do have a question, Your Honor. Am I allowed to switch probation to West Virginia if I have a place to live over there?
Well, that's something that you can file with the court, and the court can consider it at that point. But if you're doing treatment,
Right.
I think that would make it very difficult for you to get your treatment, which then would in theory violate your probation. So you may want to finish your treatment before you make.
That's what I was going to do.
Okay. All right, I'll set you back for May the 4th at 9 a.m.
All right, thank you.
Your Honor, I'll need proof of the community service on paper.
But,
All right.
yes.
Thank you. Bring that with you to the next hearing.
May 4th.
Or send it down to Mr. Cooper.
May 4th, sir.
May 4th at 9 a.m.
All right, thank you.
Michael Rowe.
You should be on Zoom, Your Honor.
Yes, sir.
All right, Mr. Rowe, can you hear me?
Yes, sir, I hear you fine.
All right, this is case number CRB 23-4, State of Ohio versus Michael Rowe. Mr. Rowe, it looks like you just have a balance of $835 remaining. And you worked off some of your fine on community service.
Yes, sir, I just made that online payment last week. I didn't have very much money to put on there, but
I do see that. All right, I'll set you another review hearing for May the 4th, 9 a.m.
all right, thank you.
Thank you.
Patricia Segraves, Jason Stapleton, Carl Tully II, Nicholas Watts, Michael Wood.
All right, Ms. Segraves?
Yes.
All right, this is State of Ohio versus Patricia Segraves, period 09-2795. All right, looks like you did community service as you were ordered. Looks like you're down to 12 hours community service left and $100. $100. I'll also set you back on May the 4th.
I'm sorry, when was that?
May the 4th,
Okay.
9 a.m.
Thank you.
Thank you. Jason Stapleton. Jason R. Stapleton. All right, this is TRC 25-1796, State of Ohio versus Jason R. Stapleton. Also application number TRD 25-525, 2420-33, A, B, and C. TRC 15-1167, A, B, and C, TRC 15. Same case. All right, time is 9:53 a.m. Mr. Stapleton decided to be here at 9 a.m. He has failed to appear. There'll be a bench warrant issued. Mr. Tooley?
Yes, sir.
All right, this is State of Ohio versus Carl E. Tooley II, PRC 05-1584 and PRD 05-1474. Okay. Well, Mr. Tooley, it's overall, it's a pretty good report, but you're not entirely compliant with your program rules. If they tell you you gotta do community service, you don't get to refuse.
No, I don't. It's just, it was just a mix-up there at first, but yeah, we got it straightened out now.
Okay. I would anticipate that going forward, this will not be an issue then.
No, it wasn't really an issue now. I mean, it turned into be one.
All right, I'll set you back for May 11th for review at 9 a.m. Nicholas Watts?
Yes, sir.
All right, this is CRB 2660, State of Ohio versus Nicholas Watts. Mr. Watts is present via Zoom, and I'll just hand you an update report. Excellent report, Mr. Watts.
Thank you, sir.
I'm going to set you back for May 11th to review.
Okay, I just had a few questions about my requirements.
Okay.
I haven't had a chance to speak to the public defender or anything like that yet. And I just was wanting to know what all my requirements entail. They're at, like, just to completion of 2.5.
It will be when the counseling center says that you are completed with treatment, and you've paid off your $275 case balance.
Okay.
Okay?
Yes, sir.
All right. See you back May 11th at 9 a.m.
Thank you, sir.
Michael Ward. This is State of Ohio versus Michael Ward, TRC 24436 A, B, and C. Oh, is it Wood?
Yes, sir.
Okay, I apologize.
That's okay.
All right, looks like you're down to $405 remaining, Mr. Wood. Do you have a payment today?
Yes, I have 20 today, and then I'd like to, Friday, when I get paid, I'd like to pay it all off, if that's possible.
That is possible. So it looks like you completed your 3-day school. I've got that in the file. So all you have remaining is that payment. What I'll do is I'll set you back for May 11th for review at 9 a.m. If that's paid off, then this matter will be that will be canceled and this matter will be completed.
Okay.
Okay?
All right, May 11th.
May 11th, 9 a.m.
Okay, thank you.
Thank you.
We're ready for arraignments.
All right, next group of cases we're going to call are some arraignments. When you hear your name called, come down to the table on my left, your right, as the last cases were called, and we will handle going through your charge or charges. Once we go through your charges, if you have a misdemeanor, I will ask you for a plea. You can enter a plea of either guilty, not guilty, or no contest. If you enter a guilty plea, you're making a complete admission that you committed the offense charged. If you enter a not guilty plea, you are denying at present time that you committed the offense charged. And if you enter a no contest plea, that means you're not admitting that you committed the offense charged, but that you're not contesting the facts and circumstances surrounding it, and I can enter a guilty finding if I believe that the state would have enough evidence. If you are unsure of what you should do, you should enter a not guilty plea. It preserves all of your rights before the court. You have the following rights before the court. You have the right to remain silent. Everything that we say in here today is being recorded, and if you come down here and you decide that you want to tell me something about your case, that may or may not be in your best interest. If you say something that is against your interest, the state of Ohio, who is listening from the back, can then get a copy of that and use that against you at a future proceeding. So you have the right to remain silent. You have the right to have counsel for any of these matters. Anything that is potentially jailable, if you can't afford an attorney, I can appoint one to represent you if you qualify. You have the right to have a reasonable bond set in this matter. And additionally, you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt.
State of Ohio versus Charles Nance, case number CRB 25331, CRB 25291, CRB 2537.
All right, this is State of Ohio versus Charles Nance, CRB 25331, CRB 25291, CRB 2537, CRB 19237. Mr. Nance, it looks like it's alleged that you have failed to appear on March 11th, 2026 for a review hearing. Do you admit or deny that you failed to appear?
I must have wrote my court date wrong. I'm sorry.
Okay.
I wrote the 26th instead of the 6th. I did 8 hours of community service Saturday.
That is correct, Your Honor.
Okay. Will you call the warrant? And I'm going to set you a new review hearing for May the 11th. And that'll be a review at 9 a.m.
Appreciate it.
Thank you.
State of Ohio versus Hannah Gooden, case number TRC 222509, ABCD.
Your Honor, if I may, I believe she only had 4 hours of community service and it was turned in this morning, and it has been verified.
Okay. This is State of Ohio versus Hannah Gooden, TRC 222509, A, B, and C. And this matter has now been completed. So we'll call the warrant that was out for the failure to appear and note that the case is completed.
Thank you, Your
Thank you,
Honor.
Ms. Gooden.
State of Ohio versus Jessica Smith, case number CRB 2621 and CRB 25780.
This is State of Ohio versus Jessica Smith, CRB 2621, CRB 25780. Ms. Smith, it's alleged that it looks like on or about March 16th of this year that you failed to appear for a review hearing. Do you admit or deny that you failed to appear?
I admit it.
Okay, do you have a reason?
I was in the program, and they don't come every day of the week always. And no, and I read my court date wrong. That's the honest truth. I'm not going to sit here and make up an excuse.
Well, I'm glad that you're in treatment and that you're doing what you need to do. Mr. Major, anything you need to add?
Your Honor, I believe she left court-ordered treatment and went someplace other than where she was supposed to be.
Yeah. I
And
did.
now she's attempting to try to get back into there, but I don't believe that she's compliant with her court orders.
Okay. Ms. Smith, where were you ordered to go to treatment?
At Restoring Hope, I was there, and then they told me, they made it court ordered. And I did leave for 4 days and got right back into the treatment facility. I was gone for 4 days.
Okay, well, here's what I'm gonna do. I'm gonna remand you into custody, and then we'll have you back out later in the docket and figure out what we're gonna do for you.
Yes, ma'am.
State of Ohio versus Linda Carpenter, case number TRC 231792, A and B.
Yes, sir.
All right, this is State of Ohio versus Linda Carpenter, TRC 231792A and B. Ms. Carpenter, it looks like it's alleged that on or about December 15th, 2025, that you failed to appear for, January 2nd, 2026, you failed to appear for review.
Yes, sir.
You admit or deny that you failed to appear?
I failed to appear. I live up a township road that's not well maintained.
Okay. Well, before I do anything here on this one, I want to have you drug screened today. So, is there anybody that wants to work on drug screen?
It's me.
All right, Ms. Taylor, if you'll follow her, we'll recall you a little bit later in the docket.
Okay. Your Honor, that's all the arrangements we have for right now. We're ready to start pre-trial.
All right, if you have a pretrial, come into the courtroom. We'll have some more arraignments, I presume, later in the docket, but they're not ready yet, it looks like.
Ohio versus Timothy Atkins, case number CRB 25580.
All right, this is State of Ohio versus Timothy Atkins, CRB 25580. Mr. DeLaw's case is set as a pretrial.
Your Honor, this is one that we had continued for 90 days with an agreement to dismiss upon payment of court costs if there were no further problems. We confirmed with the prosecutor's office and, that there have been no further problems. Mr. Atkins is prepared to pay court costs today.
Mr. Hill, is that correct?
Yes, Your Honor.
All right, the matter will be dismissed upon payment of court costs.
I'll have him see the clerk now.
All right.
Thank you.
Thank you.
All right, okay, sorry. I see you back.
State of Ohio versus Bobby Holly, case number CRB 2659.
This is CRB 2659, State of Ohio versus Buddy G. Holly. This is Mr. DeLaw's case set for a pretrial.
And Your Honor, this is one where the state wanted Mr. Holly to undergo an alcohol class, and Mr. Holly's done that. He's completed his class.
Pamela Holly? Yeah.
I think it's a case that the state may be agreeable to dismiss him.
Still put on.
Do you think that things have gotten resolved enough to be able to dismiss the charges today or not? Your Honor, on a previous day, I spoke with Pamela Holly, the alleged victim of this, and the spouse of Bobby Holly, about how we need to proceed with this with respect to the seriousness of the charges and also the fact that they are married. And even though they haven't completely resolved their issues as far as their relationship, Ms. Holly believes that it's appropriate, given his success in treatment, that we go ahead and dismiss the charges today with the payment of court costs. So we're willing to do that.
Okay.
That's agreeable, and Mr. Holly is prepared to do that today.
You can pay the court costs today?
How much is it?
You can get it done.
Yep.
Okay. And Ms. Holly, is that correct? That is your wishes that Mr. Hill had indicated before? Okay. This matter will be dismissed upon payment of costs.
You see the clerk pay court costs.
State of Ohio versus Jason McCoy, case number CRB 26101.
Right, this is State of Ohio versus Jason McCoy, CRB 26-101. And this is the law that's being set for the trial.
Your Honor, if it please the court, I've been speaking with Elizabeth McCoy, and the allegations are pretty serious, and we've recognized that, and we've been here several times. In speaking with Ms. McCoy today, she says that they do have challenges in their marriage, raising children and all the other pressures that come with having a family. And she feels as if it would be appropriate for the charges to be dismissed today. And we did discuss that previously. Back in about a month ago, 3 weeks ago, the protection order was dismissed. So we're willing to go ahead and dismiss the case today with the payment of court costs.
I don't have it today. I don't get paid till Friday.
Your Honor, we're agreeable with that proposal. However, Mr. McCoy indicates to me he doesn't get paid till Friday, so he would have to come back on Friday to pay the court costs.
We can put it back on the docket for Friday. I'm here.
That's fine. I will not be here on Friday.
I work out of town, so I will be driving back in from Indianapolis Friday, but I could send the money to my wife to where she can pull it off and come in and pay it. 'Cause I know you guys only take cash, correct? Or can I pay it over line?
You can pay it online,
Okay.
or you can send cash in. I would be willing in this situation to excuse your appearance.
Thank you.
So long as it's paid.
Yeah, absolutely. I get paid at 11 o'clock Thursday night, I'll pay it online as soon as I get paid.
I'll tell you what, he can take care of it today. He'll just go ahead and take care of it today. And I'll make arrangements with him. I can process a card transaction on Thursday.
Okay. Ma'am, you heard what Mr. Hill has indicated to the court. These were some serious allegations. Is this what you wish to do?
Yes, sir.
I don't know, what occurred, what didn't, what was accurate, what maybe wasn't, but based upon what's been represented in the court here today, the matter will be dismissed upon payment of costs.
Thank you.
All right, thank you.
Thank you, Your Honor.
State of Ohio versus Levi Short, case number CRB 26161, A and B. This is set for the regular.
All right. So the State of Ohio versus Levi Short, CRB 26161, A and B. This matter is set for an arraignment this morning. It looks like there's been a bond already posted. All right, Mr. Short, in CRB 26161A, it's alleged that on or about March 21st, 2026, you did recklessly or by force resist or interfere with the lawful arrest of yourself in violation of section 2921.33A of the revised code. That is resisting arrest. That is a misdemeanor of the second degree. Misdemeanors of the second degree carry up to 90 days in jail and up to a $500 fine. How do you wish to plead?
Not guilty.
Accept your not guilty plea in the A case. And in the B case, it's alleged that on or about March 21st, 2026, you did knowingly cause Rebecca Johnson to believe that the said Levi Short would cause physical harm to the person or property of Rebecca Johnson in violation of section 2903.22 of the Ohio Revised Code. Excuse me, that's menacing. It's a misdemeanor of the fourth degree. Misdemeanors in the fourth degree carry a maximum of up to 30 days in jail and up to a $250 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty pleas to both. Do you have money to hire an attorney?
I do. I don't have one yet because I've not had time to find counsel.
Okay. How long do you think you'll need to hire counsel?
I don't know, maybe a week, couple.
Well, I'll give you a little longer than that because it's sometimes tough to get into with attorneys that quickly.
I'm trying to find one, so.
So, how about, I'll set this for a pre-trial April the 20th. And I'll continue the bond that you've already posted. Mr. Guild, anything to add on this matter?
Probably need to have a protection order.
Okay.
No, would I have to set it up with someone to try to get my personal belongings? I just need my keys for work, actually from the residence. I have to have my keys.
Is the alleged victim here?
Is Rebecca Johnson here?
I don't believe she is, Your Honor. I didn't see her.
Well, whenever you get counsel, you'll have to work with them, and they may be able to set that up for you at that point without her being here. I don't have her here to ask her if we can send someone out.
It's, okay, it's really hard for me to continue work without my work keys, and I have to have them.
Well, we're gonna ask for a protection order, and that's gonna have to be written up. So, we can talk to Jasmine about making contact with her.
Okay.
In fact, if the court wanted to recall the case, it would give us some time to do it.
Okay, let's do that. If you want to have a seat back in the back, Mr. Short, while that protection order is being written up and prepared, the state's going to reach out to her, see if they can get her on the phone, to see if it would be possible to send someone to get your keys.
Okay, thank you.
All right, thank you.
State of Ohio recall Linda Carpenter, case number PRC 231792, A and B.
All right, this is PRC 23792 A and B, State of Ohio versus Linda Carpenter. It looks like Ms. Carpenter, you were positive for alcohol.
Yes, sir. Probably.
When did you last use alcohol?
I've been sucking down the cold liquid Dollar General cough medicine.
Okay.
I've had the crud and I've avoided, I've tried to stay home. And
Well, it looks like you're down to $210 left on your case, and that's all. You've already worked some off on community service.
yes, sir.
So I will set you back based upon your screen being just alcohol, and I don't know that, without anything further, I don't know that I have any reason to believe that you've got any other type of alcohol issues, so I'll set you back for May the 4th.
Okay, if I pay everything,
Then that'll get canceled.
okay, I plan on doing that next month.
Okay, I'll set you back, excuse me, I'm gonna set you back May 11th for review at 9 a.m.
Yeah,
All right,
I just want over this crud.
all right, it's going around, so you're free to go. We'll see you back May 11th,
Unless I pay.
unless you pay.
Okay.
If it's all paid off or worked off, then the case will be concluded.
I think all my community service is done.
It is. You can work off the fines as well, if you wish. So whether you pay it off or whether you work it off,
Yeah.
as long as it's completed, the case will be completed at that time. You won't need to review for it. All right, thank you.
State of Ohio versus Earl Carter.
Thank you.
Case number TRC 25-1974, A and B.
All right, this is State of Ohio versus Earl Carter, PRC 25-1974, A and B. This is Mr. Roger Smith's case, set as a pretrial today.
Judge, I was informed by Mr. Carter that he has an appointment tomorrow at RRS 20, which is tomorrow. I would ask him to come back, well, the prosecutor agrees, a couple, 3 weeks, see how he's doing. I understand it's his first appointment, correct?
Yes, sir.
I'd like to get a little indication of how he's doing on his treatment. He had did a lot of different things in his system, so I think it's important that he shows progress in treatment. If we could come back, we'd waive time.
Mr. Gill?
Well, we're glad he's got an appointment with RRS. We talked about that back on March 2nd.
Yes, sir, that's the earliest I can get in. I talked to Beth today, and that's the earliest she can get me in.
All right. So previously, RRS, I think, recommended you do residential treatment. And the judge said, if you want to do outpatient, you better prove you can do it.
I'll do it, sir.
Now, also, we do have a pending OVI case. We got the results back. We're ready to proceed to a trial if that's the direction we need to go, but we want to see him do well in treatment, so we're willing to give some time to make sure that that happens.
How's April 20th, Mr. Smith?
Actually, that works.
At Finland's request, this matter will be continued to April 20th, pre-trial at 10 a.m. And I'll note that Mr. Smith has waived time.
Yes, Judge.
On behalf of his client.
April 20th, 10 a.m. Make sure you get a report. They should be. All right, see you. Thank
State of Ohio versus Travis Gerald, case number TRC 25-2913, A and B.
So the State of Ohio versus Travis Gerald, PRC 25-2913, A and B. This is Mr. Smith's case, set as a pretrial. All right, to give a report.
compliant with the treatment and he's doing well. He will continue to shine household center whenever he completes here.
All right, thank you, Mr. Mill.
Judge, he has a completion date of April 6th. I don't know if you want to come back just before or just after. I would ask we continue to monitor and.
How about April 13th?
That's a good date also, yes. You're 2 for 2.
This is charged with the third offense OVI. And we need to have a resolution, either we need an indication one way or the other how they want to proceed with the case. As far as we're concerned, the treatment's a very important part of our determination of how we want to proceed. As far as the disposition that we would be seeking in this case. But if we're forced into, going all the way to the trial, then the treatment won't mean anything to us. It'll all be about punishment.
And Judge, I anticipate we can either resolve it next time or set it for trial. I just want to see him get to the finish line. And that'll help determine, do we need a trial or can we do a plea? But, I'll certainly address that with my client before the next hearing.
All right, I'll set you back, Mr. Gerald, for April 13th at 10 a.m. for pre-trial.
All right, thank you.
And I put on my notes plea or trial.
Yes, that's right.
State of Ohio versus Angela Markham, case number TRT 25-2222, A and B.
All right, this is State of Ohio versus Angela Markham, TRT 25-2222, A and B. This is Mr. Roger Smith's case as well, so I think
Yeah, we need to know contact. But call her first. Yes.
I'm just sitting here. It's probably coming out of your system.
It's coming, yeah.
Okay.
I guarantee you.
Yeah, it should. Come back.
There it is.
And I'll do all the community service I need here.
Okay. Judge, it's an ongoing case. She's not been in very long yet. I would ask we continue to monitor and see. And I'm hoping, she had a trace amount of THC metabolite. I would hope the results will be gone. It sounds like it's coming down because of the trace amount, not a continued use problem, but she understands she can't take the gummies, anything.
CBD, any of that stuff?
Yeah,
No,
will.
I have it. This next one, they're getting results today. It should be clean.
Okay. All right, we'll set you back on March the 20th.
Thank you, sir.
April.
Or excuse me, April 20th. I apologize.
Oh, you got it, yeah, right.
For pre-trial, 10 a.m.
Thank you, sir.
Thank you.
Thank you.
State of Ohio versus Carl Lee McDonald, case number TRC 26-341, A and B.
This is State of Ohio versus Carl Lee McDonald, TRC 26-341, A and B. Mr. Smith's case, that is a pre-trial.
Judge, this is I believe it's what is it? I think it's a first but fourth lifetime. I need to file discovery. I've spoken with Mr. Hill this morning. We've not come to a resolution yet. Obviously, I need to file discovery. If we could come back sometime in April. The only bad dates I have in April are the 24th through 27th, but I'm good any other time in April.
Through April 20th. There'll be a pretrial at 10 a.m. At defendant's request.
Once I have it, I'll get you in the office.
Time do you say?
10 o'clock.
I don't know it.
I just need his phone number so I can get him in the office. State of Ohio, Julie
We got you
Richard,
this too.
case
That's
number
what Frank
CRB
framed me.
2691.
You're good. Still with me, you need that on the court file.
This is State of Ohio versus Julie Pritchard, CRB 2691. This is Mr. Roger Smith's case, 17.
This is the same situation, Judge. We did not resolve this word at the initial pretrial. I need to file this history.
All right, defendant's request, this matter will be set for April 20th at 10 a.m.
You say April 20th, Judge?
Yes,
What case is this? I'm sorry, Your Honor.
Julie Pritchard, 2691,
And what date?
April 20th.
State of Ohio versus Roger L. Pritchard, case number CRB 2617.
To the State of Ohio versus Roger Pritchard, CRB 2617. This is Roger Smith's case, set as a pretrial.
Feels like the original.
Is Rebecca Pritchard here?
Yeah, she's
She's out in the lobby.
Will Rebecca Pritchard come into the courtroom, please?
Everything went well? Yeah. Okay.
Hello, How you guys doing?
Good.
How's he doing?
He's doing better. He still he's angry a little bit, but he's doing better.
Well, is he going to his counseling like he should? Okay. We want to keep that going for a while, okay?
Oh, Judge, excuse me. I believe Mr. Hill has had a conversation with the alleged victim. Things going well.
She says things are going good. She says he still gets mad a little bit, but things aren't as bad as they were. And the report from Shawnee is just a complete reversal of their normal, very sketchy, if any kind of report. They've given what looks like
I think that's the best report I've ever seen them give.
extremely comprehensive.
Multi-page report.
Yeah.
And too much to look at one time in the courtroom. But, so we're happy about that. We want to keep it going. We got happy children, and that's what we want to keep everybody happy and safe. So if they're willing to waive time, we're willing to go forward again and get another report and make sure everything's going to be okay.
We are willing to waive time, Judge. I'm good in April, except the 24th or 27th.
Why don't we go out even a little bit further into May?
My bad dates in May are the 4th, 8th, and 15th.
All right, how about May 11th?
That'll work. Keep doing what you do.
Note the time waiver by Mr. Smith on behalf of his client, defendant's request to set this matter back to May 11th for a pretrial at 10 a.m.
Coming in.
Thank you.
State of Ohio versus Logan G. Wright, case number CRB 24512, A and B.
This is State of Ohio versus Logan Wright, CRB 24512 A and B. This is Mr. Smith's case. Set as a pretrial.
Need to hear that on the TV.
Your report, Mr. Wright.
Thank you, sir.
Yeah, it is a good report, Judge. We're not anywhere, I think, near ready to complete, so I would ask we continue to monitor and come back approximately 30 days, whatever's good for the court. Except 24th or 27th of April. Those are the two bad days in April.
All right, let's do April 17th for pretrial at 10 a.m.
Thank you, sir. You have a good day.
Thank you.
State of Ohio versus Serena Sullivan, case number CRB 26120, A and B.
The State of Ohio versus Serena M. Sullivan, CRD 26120 A and B. Mr. Smith's case set as pretrial.
Oh, okay.
Yeah, right. He had original identification.
Yeah. Your stuff back. But of course you have to have a way to get to the state patrol to figure it out. Could be a favor, can you sign right there, that way the state pays me, you don't have to pay me. Yes. Judge, I believe the state's gonna make a motion to dismiss the case. We pre-tried it, and we would not object to dismissal.
Mr. Hill?
The explanation, and I tend to believe this, was that the possession of the drug abuse incidents was because she makes a habit of trying to clean up things, and that she walks highways and roads and whatnot in both Huntington, I guess over here too. And so when she was approached by law enforcement, she had those things in her possession, but I don't think that this is a substance abuse issue. So I think under the circumstances that it's appropriate to dismiss the case.
All right, so it's be nolly the state's request.
Thank you, Judge.
And I think if there could be an order saying
Yeah, there
law
is.
enforcement is to destroy the...
There's already...
Well, yeah, she gets her personal property back with the exception of these several hypodermic syringes. So if she doesn't want it back, I don't have position.
I believe they destroyed.
I figured,
after the case
okay.
is completed.
I can't imagine they wouldn't, so we're okay with that.
All right, case to be null, states of West.
Call the highway patrol, because the highway patrol arrest probably up there by South Point High School is where they give them a call, that's where you need to go pick up your stuff.
Case number CRB 25761. Ron, this is Mr. Stratton's case, and he's not here, that's why we can't do it now. I'm not sure if it's going to be charged with this, it's a cost will pay, but I cost that not.
All right, this is State of Ohio versus Jacob Noble, CRB 25761. Mr. Noble's present. There's attorney Mr. Stratton. There's not. I've got a note to file. Looks like this was supposed to be dismissed after a 90-day continuance with, is it Mr. Hill, is that with counseling and cost, or just cost?
We had requested also that he complete anger management counseling.
Yeah, I'm in the process, still doing that.
Okay. Here's what we're going to do, Mr. Noble. Your attorney's not here yet at this point, so I'm going to pass this to a little later in the docket and give him an opportunity to show up in case there's anything he'd like to put on the record. If something happens and he's not here after a reasonable amount of time, we'll recall it, and I will grant that your request to continue that to allow you to continue to complete the treatment. So you will just have to sit in the back.
Your Honor, had we heard from him today or to know whether he knew to be here?
I've not seen him.
No, sir, we have not.
I think I'll send him a text message. Maybe he can appear by Zoom if nothing else.
I would have no objection to that.
State of Ohio versus Caleb Christian, case number TRC 2678 A&D. Mr. Steyer's case, Your Honor.
All right, this is State of Ohio versus Caleb Christian, TRC 2678 A and B. This is Mr. Steyer's case set as a pretrial.
Your Honor, you may recall we discussed this case briefly in chamber, well, it's not in chambers, in the jury room. I'm going to give Mr. Hill a second to finish his text.
Next to Sean Stratton.
Good. Yeah, Caleb Christian. Anticipating a motion from the state.
Your Honor, this is one in which the facts do not line up real favorably for the state of Ohio, given kind of the lack of evidence. We may believe certain things about what happened, but we can't prove them beyond a reasonable doubt. So under the circumstances, we do know that I think we could prove without any question that Mr. Christian failed to maintain control of his vehicle. And so we would be seeking a finding of guilty on that. But the OVI case, we don't have anything other than just some very sketchy details in order to be able to prove. So we're going to have to dismiss that case.
I'm sorry, and I've discussed the matter with Mr. Christian prior to coming in here today, and he's willing to plead guilty to the failure to control.
Yep.
Is that correct, Mr. Christian?
Yes, it is.
All right. So based upon pretrial discussions and what was in the report, I tend to agree with the state. This would be a very difficult case, if not impossible, for the state to prove on the OVI. So I would grant the state's request to dismiss the OVI case, and I will note Mr. Christian's guilty plea on the failure to control. I'll enter a guilty finding. It'll be a $20 fine and court costs.
Okay.
I'm going to give you a review hearing date.
That's a separate issue to do the paperwork. Thank you.
September 21st for review at 9 a.m. If you have it all paid off, the fine and court costs, that will get canceled and you'll not need to appear. If you don't have it paid off, you'll have to appear at that point.
All right.
And talk about why you don't have it done yet at this point, and potentially get more time. If you fail to appear for a review hearing, a warrant can be issued for you, and then you take something that is non-jailable and potentially wind up in jail. So it'd be important to show up for your hearing.
Okay. How much is the court cost?
I believe the court costs are $125 in this.
There will be a court-appointed counsel fee of $25 as well. There may be other miscellaneous costs, but about $150 is what you should probably count on.
Okay.
And if you want to give it a few minutes, you can go out and ask the clerks and then give you the total.
Oh, okay, thank you. I'm good.
It'll take a few minutes for everything to cycle through the computer, so.
All right. And there's not going to be any probation on this, which takes a little bit of time.
Thank you, Your Honor.
All right, thank you.
Yeah, you can go.
State of Ohio versus Cody Mead, case number TRC 253047, A, B, C, and D. TRD 251553, TRD 251873, A and B, TRD 2221, A and B. Case number TRC 221690, A and B, and case number TRC 23152, A, B, and C.
All right, this is State of Ohio versus Cody Mead, TRC 253047, A, B, C, and D, TRD 251873, A and B, TRC 2221. A and B, TRC 221690, and TRC 23152, A, B, and C. This is Mr. Steyer's case that is a retrial.
Your Honor, this is an OVI case that's been pending for a little bit of time, but Mr. Mead has a number, as you've noticed, of older cases that he has to make some progress on. We have a positive review, or not review, I'm sorry, a positive report here from the Recovery Ranch, which is his treatment provider, which I think the court probably got a chance to read. It's fairly brief but positive. It looks like he's moving to a 2.1 level of care. I believe that is outpatient?
No, it's still inpatient.
Still inpatient. So he's not going to quite be ready to start making major progress on the other older cases yet, but looks like we're making progress toward a time that he's going to be able to do that. At this point, for the time being, I think we should continue to watch his progress, see where things land, and go from there.
How's your calendar for April 24th, Mr. Steyer?
April 24, Your Honor, is, I'm here that day, Your Honor.
All right, I'm going to, defendant's request, I'm going to set this matter for April 24th for a pre-trial at 10 a.m.
And just for the record, we would waive time constraints to accommodate that.
What date is that, Your Honor?
April 24.
And I'll note the time waiver for the record.
Your Honor, we're ready to go to Lawrence County Jail. State of Ohio versus Matthew Becker at the Lawrence County Jail, case number CRB 26160.
All right, Mr. Bachner, can you hear me?
Yes, sir.
All right, this is State of Ohio versus Matthew Bachner, CRB 26160. Mr. Bachner is present via Zoom at the Lawrence County Jail. Mr. Bachner, we're going to go through your charge, and then I'm going to ask you for a plea. You can enter a plea of guilty, not guilty, or no contest. You enter a guilty plea, you're admitting a complete admission that you committed the offense charged. If you enter a not guilty plea, you're denying at present time that you committed the offense charged. And if you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not denying the facts or circumstances surrounding that offense. And if I believe that there's enough evidence for the state, I can enter a guilty finding. You feel like you understand my...
I do.
Okay. All right, you have the right to remain silent. Anything that we're doing in here is being recorded today. You have the right to have counsel. If you can't afford counsel, I can appoint counsel for you at no cost. You have the right to reasonable bail, and you have the right to force the state to reach every element of the offense charged beyond a reasonable doubt. You feel like you understand my explanation of your rights?
Yes, sir.
All right. Mr. Bachner, it's alleged on or about March 21st, 2026, you did with purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise, without the consent of the owner or person provided with consent. That's an alleged violation of Ohio Revised Code Section 2913.02A1. Theft is a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
It sounds like you're not guilty. Would I be able to get a law bond on this matter to come back to court?
Well, we'll discuss that, as far as that goes, but you'd have to...
Well, I was just asking, oh, I'm sorry, Mo. I was asking because my son, I'm the sole custody of my child. He lives with me right now. I made a mistake. And it's just me and him. His mother has passed away. And I didn't know what would be the best route. Just had to think it straight up to maybe get back to them.
Okay, well, here's what I'm going to do. I'm going to enter not guilty on your behalf. Do you have the money to hire an attorney?
Sir, I work for the union and I'm laid off right now. I'm just getting ready to start a job. So no, I don't.
Okay, I'll find the indigent. I'll appoint Mr. Morford to represent you. He's here in the courtroom. Mr. Morford, I don't know if you heard, this is a M1 Walmart theft case. Do you want to be, Mr. Hill, do you want to be heard on the matter of bond?
Well, under the circumstances, we're okay with an OR bond. There may be some more charges coming.
Okay.
But we don't have anything else today.
All right, I'll issue a $2,000 OR bond. So, Mr. Bachner, you're going to be able to sign your bond, and you'll be released today. Mr. Morford, when would you want to come back?
Time at your convenience. My trial calendar is pretty much clear for the next 3 months.
Okay. Let's do April 27th. At 10 a.m.
May I have your bond?
You may, and Mr. Bachner, as a condition of your bond, you've got to stay out of Walmart.
Yes, sir. Thank you.
No problem. Mr. Bachner, you're going to need to be back April 27th at 10 a.m.
Thank you.
Thank you.
State of Ohio versus Charles W. Burks at the Lawrence County Jail, case number CRB 26-103.
All right, this is State of Ohio versus Charles Burks, CRB 26108. And this is Mr. Steyer's case.
Your Honor, I have filed a suggestion of incompetency as well as a written plea of not guilty by reason of insanity in this matter. Additionally, prior to my first meeting, Mr. Burks, the jail had him looked at by Appalachian Behavioral Health, who issued a pink slip. However, they have not picked him up. So my understanding is he's just been sitting there for a couple of weeks kind of waiting for a bed at ABH to open. This point, the case is, I believe, under an automatic stay, but I think it is worth keeping dates set so that we don't lose track of it in the event that progress is made.
All right. We just set one for April 27th. And so...
We set one for April 24th with me. The 27th, I actually have a jury trial.
Oh, I apologize. April 24th. So we'll keep that on for April 24th at 10 a.m. for a trial.
Thank you, Your Honor.
Thank you.
State of Ohio versus Daniel Doss, case number TRC 26-483, ABC and D. Jeremy Spencer is on deck.
All right, Mr. Doss, can you hear me?
Sir.
All right, this is State of Ohio versus Daniel Doss, TRC 26-483, A, B, C, and D. All right, Mr. Doss, we're going to go through your charges here, and then at the end of it, I'm going to ask you for a plea. You can enter a plea of guilty, not guilty, or no contest. If you enter a guilty plea, you're making a complete admission that you committed the offense charged. If you enter a not guilty plea, you're denying that you committed the offense charged. And if you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not denying the facts and circumstances surrounding the offense, and recognize that I can enter a guilty finding in the event that I think the state will have enough evidence. Do you feel like you understand my explanation of the pleas?
Yes, sir.
All right, you have the following rights before the court. You have the right to remain silent. We're recording everything in here today, so if you say something against your interest, that can be used against you. You have the right to have counsel. If you can't afford counsel, I'll appoint counsel to represent you at no cost to you. You have the right to have reasonable bond set, and you have the right to force the state to prove each and every element of the offense beyond a reasonable doubt. Do you feel like you understand my explanation of your rights?
Yes, sir.
All right. Mr. Doss, it's alleged that on or about March 21st, 2026, in Mason Township, that you were operating a motor vehicle under the influence of alcohol or drug abuse or a combination thereof, and that there was a urine screen done with a prior, well, it's 2015, so that prior won't count. So this is the first offense. That's an alleged violation of the Ohio Revised Code, section 4511-19.A1A. That is a first-degree misdemeanor. Maximum penalty on that is up to 6 months in jail and up to $1,075 fine and a 3-year license suspension. Minimum penalty on that is either 3 days jail or 3 days at a driver intervention program, a $375 fine and a 1-year license suspension. On the B case, it's alleged you were operating on March 21st, 2026 in Mason Township with no valid driver's license. That's an alleged violation of Ohio Revised Code section 4510.12. That is a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. On the C case, it's alleged on March 21st, 2026 in Mason Township that you were operating a motor vehicle and violated Ohio's window tint restrictions law. That's an alleged violation of Ohio Revised Code section 4513.241. That is also a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. In the D case, it's alleged on or about March 21st, 2026 in Mason Township that you were driving an unsafe vehicle. That's an alleged violation of Ohio Revised Code section 4513.02. That is a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. How do you wish to plead?
Can I plead different on different things, Your Honor?
Let me ask you this. How do you wish to plead on the OVI?
On the OVI, I told the officer that I had done some meth the day before, but not that day, so that's why I asked if I could do the drug screen. That way I could show that my levels were slow, that I wasn't under the influence.
Here's what I'm going to do. I'm going to enter a not guilty plea to all charges.
Because the window tint,
hang on, Mr. Doss. It might be in your best interest for you not to say anything else.
Sir, sorry.
It's all right. I'm gonna enter a not guilty plea on your behalf. Do you have money to hire an attorney?
What is it?
Do you have money to hire an attorney?
No, sir.
All right. I'll appoint Attorney Luke Steyer to represent you. This is a urine screen, Mr. Steyer. How far out do you want to go?
Generally, what we've been doing is going about 6 to 8 weeks out. June, surely, oh no, I've been in April, I'm looking, okay. The 24th is about a month out, so May 1st.
All right, I'll set the hearing on this for May 1st of 2026. Mr. Hill, matter of bonds.
Your Honor, normally, when this is a charge like this, the person's not going to be in jail 2 days after. So I don't know what's going on there, whether he's being held for some other reason or...
Can a jailer hear us?
Yeah, they're asking for jail. Here, on. Yes, Your Honor.
Is he being held on anything else other than this charge?
I'm not sure, let me check for you.
Okay.
No, he's not, Your Honor.
Okay, not being held on anything else. I'm a little concerned about well, let's get him back on now. Thank you.
Okay.
All right, Mr. Doss, can you hear me?
Yes, sir.
Okay. Well, Mr. Hill, I'm a little concerned about him mentioning the methamphetamine.
Me too. I'm going to look on here and see if I can see some indication as to...
I'll give you a moment.
Passenger. Well, Your Honor, I do have concerns. Maybe that's why he's still in jail, I don't know, but, so maybe Mr. Steyer would suggest something here.
Would you be willing to take to do an evaluation for possible substance abuse treatment?
Yes.
And you understand that if the court makes that a term of an OR bond and they require you to do treatment, you're going to be required to do that by the term of the OR bond?
Yes, sir.
And if you leave treatment or fail out of treatment, that the court's liable to issue a warrant, you're going to wind up back in jail.
Yes, sir.
In that case, then, Your Honor, I would ask for an OR bond with a requirement that he get an assessment for treatment and do whatever follow-up care is indicated. Sir, do you have a medical card?
Yes, sir.
What state's medical card do you have?
Ohio.
So any of our usual treatment providers should be able to work with him. So I would at this time just ask for an OR bond with a requirement of an assessment and follow-up treatment as required, and then maybe have this case, well, I guess we're going to have to recall this if someone's talked to him, realistically.
All right, Mr. Doss, I'm going to have someone call and speak with you down at the jail to do an assessment on you, and then we'll have you back out to determine what the bond's going to be at that time.
Okay.
Thank you.
All right, thank you.
Thank you.
May I approach?
You may.
Grab that file.
What happened?
Federal Law versus Jeffrey Spencer, Lawrence County Jail. Case number CRA 26162, CRB 26163, and TRC 26484. Tara Stover is on the...
All right, Mr. Spencer, can you hear me?
Yes, sir.
All right, this is CRA 26162 and CRB 26163, TRC 26484, State of Ohio versus Jeffrey Spencer. Mr. Spencer, we're going to go through your charges here, and I'm going to go ahead and give you since you're charged with a felony, I'm not going to ask for a plea from you today. But I am going to go through your rights. You have the right to remain silent. Anything you say can and could be used against you by the state of Ohio. It's all being recorded. You have the right to have an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at no cost. You have the right to have a reasonable bond set in this matter, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. Do you feel like you understand my explanation of your rights?
Yes, sir.
All right. Mr. Spencer, we're going to go through CRA 26162 first. All right, Mr. Spencer, it's alleged on or about March 23rd, 2026, you did knowingly obtain, possess, or use methamphetamine, Schedule II controlled substance in violation of Section 292511 AC1A of the Ohio Revised Code, that's possession of drugs, the felony of the 5th degree. Felonies of the 5th degree carry up to a maximum of 1 year in prison and up to a $2,500 fine. In CRV 26-163, it's alleged that on or about March 23rd, 2026, you did knowingly use or possess with purpose to use drug paraphernalia, to wit, 1 methamphetamine pipe, in violation of Section 2925.14C1 of the Ohio Revised Code. That's possession of drug paraphernalia. It's a misdemeanor of the 4th degree. Misdemeanors of the 4th degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. And in TRC 26484, it's alleged on or about March 23rd, 2026 in Union Township that you're operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof. And that, Mr. Hill, do you have this charge in front of you?
I do.
On the OBI, there's a section that lists a criminal refusal, but it also remarked that there's a urine screen.
Well, let me see. Let me read the.
Well, it looks like it was a refusal.
Yeah.
All right. So that's an alleged violation of Ohio Revised Code Section 4511.19A1. That is a first-degree misdemeanor. Maximum penalty on that is 6 days jail or 3 days jail and a 3-day DIP program. A $1,375 fine, a license suspension up to 3 years, and the minimal penalty on that, or excuse me, maximum's up to 6 months. The minimum penalty on that is 6 days jail or 3 days jail and 3 days DIP program, and a $375 fine, and a 1-year license suspension. It's also alleged that on March 23rd, 2026, in Union Township, that you were operating a motor vehicle under the influence of alcohol or drug abuse or a combination thereof, and that you refused a screen after having a prior offense. That's an alleged violation of Ohio Revised Code Section 4511.1982. First-degree misdemeanor, maximum penalties up to 6 months in jail, as well as the same penalties as the guy that I just recited. Mr. Spencer, do you have money to hire an attorney?
No, sir.
Are you working currently?
No, sir.
All right, I will appoint Mr. Attorney Roger Smith to represent you.
Can I say something, please?
No, it'd be better if you didn't. It's being recorded.
All right, Mr. Hill, do you want to be heard on the matter of bond?
I was just gonna ask for no war bond where I live in Proctorville.
Well, I'm going to ask for one.
Well, I don't have a problem with the no art bond, and I remember I've known Jeffrey before, and it's been a long time. But
Yes.
he was on a bicycle, and he got stopped for an OVI on his bicycle, and then other things happened. And it's just really the concern about having being in possession of the meth that is the most concerning thing to me. And we'd like to see him get into some treatment, if he'd be willing to do that in order to get out of jail today.
Mr. Smith?
Judge, could you hear Mr. Hill? He wants to know if you were willing to do treatment, have an assessment done, and if treatment's recommended, that you would comply with treatment and get out of jail today.
Yes.
Okay, be SUD treatment for the methamphetamine. Somebody will call down there, talk to you, do an assessment. We'll call you back up. I would presume you'll qualify. Let me ask you this. How do you pay for medical care? Do you have a medical card, insurance? An Ohio medical card?
Yes, sir.
Judge, I would ask that somebody do an assessment and have it recalled.
I saw Taylor's hand first, so I'll have Taylor reach out, and then we'll recall this a little bit later, Mr. Spencer.
So you'll call me back today?
Yes. She's gonna reach out to you at the jail, do an assessment, and then once we have the results of that, we'll have you back out here today.
Okay.
I do.
I'm not sure how I pay for that.
Something like that. I didn't understand.
State of Ohio versus Terrence, case number CRB 25590. And Brianna is on deck.
Mr. Hill, while we wait, did you guys make contact on Levi Short?
I did.
Okay.
Yes.
Let's go ahead and recall State of Ohio versus Levi Short, CRB 26-161 A and B. We were recalling this matter based upon. Okay, that's fine. Thank you. We're recalling this on the matter of the temporary protection order. The state is going to reach out to see if Mr. Short could get some of his personal belongings.
So his brothers are at God's Clothing, and she don't have a problem with his brother contacting her again to make arrangements by getting his keys to the vehicle. He wants him to a toolbox, but he'll only have the key to the toolbox.
Okay.
So he needs to give those keys to his brother, so his brother can unlock the toolbox and get his car keys, and then the brother can get his vehicle.
All right, so Mr. Short has a brother that Ms. Johnson is okay with helping to make sure he gets all this stuff.
Okay.
Okay.
And we do request a protection order in the meantime.
Yeah, he's granted. Mr. Short, what is your brother's name so we can put it?
Eli Short.
Okay.
He had went and got some of my clothes, but the keys I need are actually locked up in a safe, and I have those keys, but in order to get them, he has to go in the house to get them.
And she's fine with that. He just needs to contact her to make arrangements.
That's fine. That's fine. I'll have him contact her.
All right. Other than Eli Short contacting her, you can't have any contact.
That's fine with me. I'm fine with that.
All right. We already set your next hearing for April 20th.
Yes, sir.
At 10 a.m. for a pretrial. I'm going to go ahead and sign this. You'll just need to hang out just long enough to get a copy of it, and then you're free to go.
Thank you.
All right, thank you, Mr. Gordon. All right, Ms. Stover, can you hear me? All right, Ms. Stover, can you hear me?
Yes, sir.
All right. This is case number CRB 25590, State of Ohio versus Kara Stover, CRB 25590. All right, Ms. Stover, it was alleged that on or about October 31st of 2025, you had failed to appear for a sentencing hearing. Do you admit or deny that you failed to appear for that hearing?
Yes, sir.
Do you admit or deny that you failed to appear?
I do that I wasn't here. Yes, sir.
Do you have a reason why you failed to appear for that hearing?
I was actually in court that day, but no, I don't have a good reason. I ended up leaving, I do have failure to appear, so, no, sir.
Well, I see on that day, it looks like you had a failed drug screen that day. That probably has a lot to do with why you didn't appear. Be my,
Possibly so, sir.
okay. You were in treatment at that point.
Yes, sir.
All right, here's what I'm going to do. I'm going to appoint Attorney Morford in this matter.
Sir?
Did you hear me?
No, I'm sorry.
I'm going to appoint Attorney Butch Morford to represent in this matter.
And Your Honor, I don't know if it probably doesn't make any difference, but Ms. Stover was with Mr. Benninger when he got theft at Walmart. I think that's, so Mr. Morford's already been appointed to represent Mr. Benninger.
It would make a difference. All right, Mr. Morford, you can't be on this one, Mr. Morford. It looks like you got the co-defendant.
Understood, Judge.
I'll appoint Attorney Roger Smith.
Okay.
I'm going to wait for him to come to the courtroom. All right, Mr. Smith's now in the courtroom. Mr. Heel, matter of law. This was a failure to appear for a sentencing hearing. Ms. Stover has admitted the failure to appear. Looks like back on October 20th of last year, she was here in court, got drug screened. There was a positive screen, and it looks like she may have left the building at that point. She was in treatment, it looks like, or had an appointment after court at Bethesda, but I'm going to guess did not appear for said appointment.
So, Your Honor, she pled guilty back in September 25 for theft from Speedway. And this was not a shoplifting case. She was an employee. And she took $537 from Speedway. So this is pretty serious. No, she hadn't been ordered to yet. She's pled, but she hadn't been sentenced. And,
Yes, sir.
And I think under the circumstances, I don't know if the court feels comfortable going ahead and sentencing her today, but we think that she should receive 6 months in jail and be ordered to pay restitution to Speedway. And then, after maybe she's had some time to consider what she didn't do before and she should have, by having some time to meditate in the Lawrence County Jail, maybe she could go back to treatment if they would take her. That would be our approach.
Mr. Smith?
Judge, I would ask, since he be delayed, then I'll reach out to Taylor and see if possibly Bethesda would, I don't know if take her back's the right word if she never showed up, but would agree to take her.
Yeah.
Okay.
She was the young lady we had all the harassment online, letters sent to employees, text, absolutely not.
You mean after she left there?
Oh, yeah.
It wasn't harassment, I'm sorry. I was just trying to
Well,
figure
ma'am,
out what's going on.
I'm going to go ahead and stop you at that point. It'd probably be in your best interest not to say anything at this point.
Yes, sir.
Here's what I'll do, Mr. Smith. I'll give you an opportunity to call down and speak with her.
Yes.
As well as maybe give you the opportunity to see if you can convince another treatment provider to take her. It's like Hometown is raising their hand that they might be willing.
Call the jail and,
Yes,
if they could call the jail and talk to her, I'll also talk to her afterwards.
Sounds like it could be buyer beware, but I'll at least give you the opportunity to have those conversations, Mr. Smith, and then we'll determine, based upon the substance of those conversations, whether we let Ms. Stover go back to treatment or whether she gets sentenced to 6 months in jail today.
Thank you, Judge.
All right, well, we'll call this a little later docket. Do you want a copy of it?
If I could borrow that, please.
You may.
State of Ohio versus Brianna Christian at the Lawrence County Jail, case number CRA 26135. Mr. Morpham's case.
All right, this is State of Ohio versus Brianna Christian, CRA 26135. Matter is set for a bond hearing today.
We're waiting on that. Waiting on that.
Okay.
She should have an ankle monitor today to be released to us.
Okay, so we released the GPS ankle monitor
Yes.
for inpatient care. Okay. Ms. Christian, can you hear me?
Yeah.
All right, we had you back on. Apparently there wasn't an ankle monitor available on Friday, but it looks like there will be one available for you today. So I would anticipate that Bethesda's gonna come get you as soon as that ankle monitor is put on.
That's the plan.
All right, Mr. Morford, when do you want to come back?
We're good, Judge, thank you.
When do you want to come back?
It's up to you, Judge. I'm
Okay.
fairly at your convenience.
Let's do April 24th.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And that'll be a preliminary hearing. Mr. Morford, do you want to wait time on the phone right here to make that?
So wait, yes.
All right, thank you, Ms. Christian.
Thank you.
Your Honor, we had some recalls from the jail, but we're not ready for those yet, so come back to you. State of Ohio versus Melissa Hardy, case number CRB 2616. Mr. Morford is her attorney. Melissa Hardy.
State of Ohio versus Melissa Hardy, COD 2616. All right, Ms. Hardy is present, Mr. Morford, and we're set as a pretrial. And it looks like Ms. Hardy has been treating with Shawnee Family Health Center.
Do you have a report?
I actually went to my psychologist I've been seeing since 2019. And he gave me a letter to prove that I was there.
You want to hand that to your attorney, please?
Yeah, there's two of them. He said there was an error on one of them, but they say the same thing. He said that he'd like to see me in counseling with my mom.
Courtney Hardy here.
My friends.
You may.
I'm also willing to do a drug screen.
Well, Mr. Hill, you've had an opportunity to read the report. Did you have an opportunity to read the report?
No, I just took the information on the card and
You may want to read a copy of the report.
okay.
was a little confused during the session because,
Is this somebody you've seen before?
he's my psychologist.
Well, I mean, it sounds like you went, but you didn't sound like you were very cooperative or wanted to be cooperative.
Well, we talked and had a good session, but I've talked to him since 2019 about my family issues as needed, and I've asked for us to go together, and I just get refused. But I was confused during the session because when Courtney filed the charges, it started between me and my mom, and it turned into a whole family spew.
The last time we were here, there was a mention of Valley Health. Does this person also have an association with Valley Health, the doctor? Or,
With Perky?
Yeah.
That's who I seen with my mom.
Okay, because on February 23rd, you said that you had a counselor at Valley Health. But you hadn't,
My mom had recommended me to see Stephen Perky. And I seen him a couple times, and he transferred to Valley Health.
well, I guess my question is, where would Miss Hardy feel comfortable going? Because we've talked about Valley Health, we talked about Shawnee, OVP.
There's a prior report from Shawnee in there, in the file. It seems, and perhaps I'm wrong, Ms. Hardy, but it seems to me that you're just shopping providers and trying to get the answer that you want.
No, I'm sorry. I'm comfortable seeing Dr. Frederick.
So if you're comfortable going there, I will allow you to go there, but you're gonna have to be cooperative. If he wants to speak, whoever he wants to speak with to get more information, you're gonna have to be cooperative.
That's fine. I stopped going to him because I was trying to do family counseling, but nobody wanted to see him. But I'm comfortable with him.
Mr. Morford, thoughts?
Judge, I'd like to see her have a chance with Dr. Frederick. If she comes back and there's a problem, then we may be considering a different disposition.
That's fine. Where does it look now for you?
Is there something you want me to focus on with him?
With whatever he believes, and it's up to him, that he believes that he needs to give you adequate care. And if he tells you that you need to do something, you have to do it.
Yeah.
It's not your choice anymore. You understand that? Okay. If he feels that you need further care, he can refer you. That's different, and I'm sure that he will put in here that, in his report, that he can't help the issue that they're having, and he's referred you somewhere else. And if he refers you somewhere else, you've got to go do that. But only if he refers you, and only if he lets the court know through his report that he has referred you.
Okay.
Does that make sense?
You lost me at the end.
Okay. So if he says that you need treatment by somewhere else, so whether it be a family counselor or something else, he can make that referral. But I presume, and he will need to you'll need to let him know, if he does that, he'll need to put that in the report.
Okay.
So it's not, you think you need this, so you're going to do this, or you don't want to do this particular treatment, so you're going to do this instead. It's what he says. Is that clear?
Yes.
Okay. All right, Mr. Morford.
At least a couple of weeks.
How about April 13th?
That's good here, Judge.
All right, that'll be a pre-trial at 10 a.m.
What's the date, Your Honor?
April 13th.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Well, I've been using
State of Ohio versus Matthew Hall. Case number TRC 26136, A and B.
needs. Here's the thing.
All right, this is State of Ohio versus Matthew Hall, TRC 26136, A and B. This is Mr. Morford's case, pre-trial and preliminary hearing.
So what happens?
It shows $52 on the second.
You said hold on to it. On 219.
Yeah.
We have grace writing this the first time. Yes.
Oh, Roger's gonna cover it for you.
This is one of the best reports I've seen in a while, Mr. Hall.
Your Honor, if I may, I apologize on the community service. I just looked it over, and this will not be acceptable. It was done at the treatment facility. We do not accept it from the treatment facility. It's got to be through an outside organization. So this will not be accepted.
Okay. Well, Mr. Hoff, I applaud your work, and I'm sure that's part of your program, is that you have to do those things.
No, I actually choose to do these on the
Okay.
side.
You'll need to do, for it to count here, you'll have to do it through an outside agency, a nonprofit of some sort. Okay? All right, Mr. Morford?
It was said about the same time, Judge, 13th or so.
All right.
And later.
The defendant's request will set this matter for a pretrial and preliminary hearing on March 13th at 10 a.m.
Your Honor, if I could.
Excuse me, April 13th.
If I may, Your Honor.
Okay.
My initial thought on this was that the case should go to the grand jury, just because of the seriousness of it. Although, then when we came into court and he agreed to go to treatment, we decided we would hold off on a determination of that. It's good that he's got a good report today. This is not the kind of a case that's just going to go away, though, because he goes to treatment. We do have an OVI, and these endangering charges are serious. So we want to have some movement towards a resolution of these things here in the misdemeanor court to keep us from taking them to the felony court. In other words, we need to have a reckoning on the OVI, and we could keep the endangering charges pending, and maybe even dismiss those if he's successful in his treatment and completes it. But we do need to resolve the OVI.
Mr. Morford?
Judge, we would agree with that.
Okay, for the OVI, what plea is your client wishing to enter?
Judge, I believe we're going to have a change of plea with respect to the OVI.
Okay, which plea does your client want to enter?
Guilty.
All right, I'll accept your guilty plea. And enter a guilty finding. We're going to delay and set this matter, it will now be a sentencing hearing on April 13th.
What day, Matt, Judge?
April 13th.
April 13th, thank you.
And the remaining charges will pen, there'll be a sentencing hearing and a preliminary hearing.
Your Honor, I'll set up speaking to that also.
Thank you, Your Honor.
State of Ohio versus Peggy Miles, case number CRA 26116, CRA 26136.
This is State of Ohio versus Peggy Miles, CRA 26116, CRA 26136.
I believe she's not been compliant with services.
Has not been?
Has not been.
Okay.
I've been there every day.
Maybe I've got the wrong one. Can I have 2 seconds?
Yeah, I believe you do.
I
think you do.
Okay, calm down. It happens.
Your Honor, you can call my caseworker if you need to.
She's calling now.
Okay.
Here, I apologize. She is compliant. I have another policy. It is not.
Okay.
Thank you.
Yeah, but I'll tell you what, if she tries to say, I don't know what to do such a thing, it's gonna happen.
Because I've been there. I've even made some up that I had to miss because my daughter's sleeping.
All right, Mr. Morford?
So,
Yes, Judge.
Bob, she's compliant,
The thing about
so it's a
this,
good
I'm in
report.
treatment, I'm not even from the
Stay. Stay the course, Your
I'm in
Honor.
treatment in London.
Let her
As it is,
finish
the
treatment.
treatment I'm in here, I'm not even on drugs. I mean, that's like, it's not even helping me. No. I don't know. They never got out. I haven't already called them. I need to get back to it. I got paperwork in my car right now about my treatment in London. I've been going through.
Judge, I think maybe we ought to set this for another pretrial. There seems to be a disagreement between treatment provider and the client as to what has been done and what's not been done.
It appears that she's also seeking, she also has treatment in London, and she's actually got employment in Columbus. She's sticking here to complete the court's requirements, but I'm not sure that it's conducive, I guess, maybe.
Your Honor, may I say something?
That'll be up to you and your attorney. Now, everything that you say is, I'll go and advise you, everything
I've never done drug
is
money.
being recorded, so if you say something against your interest, it can be used against you.
And I'm just waiting on to get this done, to get back to work and my treatment in London.
You can tell them that if you want.
They got me in treatment for drugs. I've never done drugs a day of my life. The only thing I do is drink beer. I'm in treatment in London, Ohio right now. I've been in it. I have paperwork in my car. I just need to get back to Columbus to my job. She's willing to drop charges. I mean, it was all a big misunderstanding.
I'll stop you for a second. Her being willing to drop charges isn't the end all be all. It's up to the state what they want to do.
Okay.
I'm just here to call balls and strikes. I don't know what the state's intentions are at this point or not. I just know that presently you're that's done, and I know what the charges are. I don't know anything about the veracity of the charges, nor should I at this point.
All right.
Ultimately, it's up to the state of Ohio as to if they wish to proceed or not proceed.
Right.
And so, go to Mr. Heald, once he's had an opportunity to look through the file and indicate how he wants to proceed.
I guess it would be helpful to know what she's in treatment what caused her to be in treatment in London, Ohio.
My OBI charge.
Alcohol, not drugs.
Okay.
She's never done drugs a day in her life.
Well, I mean, I guess from my perspective, I think of addiction as being, whether it's alcohol or drugs, it's still needs to be
But would
addressed.
AA meetings be more effective than seeing an outpatient program with people with drugs, not alcohol?
So, I mean, there are allegations that there was violence, and this is a felony charge. Excuse me, I'm sorry. We would be okay with just going ahead and taking the case to the grand jury. And I'm sorry, I'm having an attack here. If that's what they want to do, we'll just...
We'd rather keep the distance, of course.
I don't know if I gotta be excused for a second.
You may, Mr. Hill.
Everything's better. Sorry about that, Your Honor.
No problem.
So, okay, so it's only alcohol. There's only a slap on the head. She's got bigger fish to fry in London, Ohio. The victim doesn't want to pursue it. She's sorry she ever wrote a statement.
I'm sorry I ever even called 911. It's not done, it doesn't do nothing, it doesn't help. I'm just gonna be honest, I've been to prison, I know what it's like. She does not deserve to be there, at all whatsoever. I don't want none of this to go through, I want it all dismissed. It's done nothing but hurt instead of help. We have our issues, but we don't need anybody involved to try and help us with it.
So, I'll leave it to the grand jury.
All right.
Then they can discuss it at the grand jury.
All right, that's state's request. These matters are hereby acknowledged to the grand jury. And what that means, Ms. Piles, is they're being dismissed out of this court. You will not have to come back here for them. State can either attempt or not attempt to take these matters to the grand jury. That is their decision. So they may or may not do that. He's acknowledging them, indicating his intent to take them to the grand jury. So if he does and they get an indictment, you'll then be in the common police court going forward. If they do not take it or it comes back as a no bill, then he will not have to go to common police court. He is free to take it back as many times as he believes justice requires. So one no bill doesn't necessarily mean he can't take it back again. But ultimately, that is state's prerogative on that. So as far as what you have in this court, at this point, it's now dismissed out of this court. So I can't promise you it's not going to come back up later at another court. Mr. Morford will be able to explain got to you a little more in depth, but as far as the case goes here, the case has been acknowledged to the grand jury.
Thank you, Your Honor.
Thank you.
Thank you.
How am I gonna know if it goes? Okay, thank you.
Yes, sir.
State of Ohio versus Shane Sowers, case number CRV 25186 and CRV 25295.
All right, this is State of Ohio versus Shane Sowers, CRV 25186. This is Mr. Miller's case, and it's set as a retrial.
How you doing, Shane? Captain going okay?
Okay. That's good news. Well, thank you. So, that's good. So you're probably ready for us to get rid of this, aren't you?
Yes. Maybe he's also, because she has money to work, she's been married 37 years.
Okay. Well, he's finished his counseling. Which is good. Your Honor, as Mr. Sayers has been successful in his treatment, and his spouse says the same thing. And we're really happy to hear that, because it was kind of rough in the beginning, didn't know what we were going to end up with. But because he's done so well, we are willing to go ahead and dismiss the charges today.
Mr. Morford, I presume there's no objection?
Judge, you taught me when to be quiet.
All right, Mr. Sowers, you've done well. It's been a long and windy road, but you're there now, and so this matter's dismissed.
Thank you, all.
Thank you.
Yep, charges are dismissed. Good luck to you. Thank you.
State of Ohio versus Robert Bayer, case number TRD 062492, ABC and D. Robert Bayer.
Robert Bayer.
I think this is mine. It says, I don't know if it's Mr. Starr, I drove through it, but I haven't seen it. This is a 20-year-old TRD case. I think
Like
that,
Mr. McWhorter was pointed.
yeah, this is like a dinosaur, but
I can contact him and see if he can be here.
yeah, probably. I think we're down to the TRD case or some other cases.
There's only the TRD 062492 was all.
I would ask the state to dismiss a 20-year-old TRD case. I would hope they would do that in Louisville.
And it looks like it did 6 hours. Well, no, that's some time ago.
We're okay with doing that, Your Honor.
Just nodding.
Well, he still owes $509.
Maybe put him on the review docket. I don't. I've just had no contact with her here recently.
Okay.
So however the court wants to handle it.
Why don't we do this? Let's,
Does he have a bond?
It's on the sentencing docket, he should have a bond up.
It's not on the
It's on the pretrial docket.
it's on the pretrial docket, and it's just, I don't see a bond in here.
I don't know if it's one we
Looks
can,
like he's just being brought back to make sure that he's working towards doing things. Here's what I'll do. I'll do a bench warrant issue in 7 days. I'll give you a chance to reach out.
I'll try to find him, yeah.
And I'll be here in 7 days, so
Okay,
we'll
yeah.
sort it out.
I will reach out to him, Judge. Yeah, I think we can resolve this one.
State of Ohio recalls Jacob Noble, case number CRB 25761. I understand Mr. Smith is standing up for Mr. Stratton.
Okay. All right, we're back on
I will. I didn't know. He didn't get a hold of me.
CRB 25761.
He thinks he did.
Oh, I'm sorry. Go ahead.
I'll help you through it.
In fairness, I looked at my phone. He very well could have.
This was a 90-day with counseling and costs. Mr. Noble indicated that he was in the counseling, but he hasn't completed yet, and so I figured we'll just come back on another date.
Sure.
I'm guessing you don't have any idea about Mr.
I
Stratton's
do not, and I still don't see his text, but I'm happy to stand up and help him.
Fair enough. We'll set it for April 27th
Okay.
for a pretrial. Go out about a month. You'll need to get in contact with Mr. Stratton, Mr. Noble.
I just tried to contact him outside and I didn't get any answer. I left him a message.
Yeah, I don't know what his schedule is. He may be in a trial or some other court hearing.
April 27th, Judge.
April 27th at 10 a.m. And you'll need to bring an update from your provider showing where you are in the...
Bring an update?
Yeah, bring an update.
Okay.
From the provider for that hearing.
Thank you, Judge.
Thank you, Mr. Smith, for graciously standing in.
Well, sure. Where are you treating that?
I think it's called My Integrity.
I'll just put provider.
Yeah, My Integrity Council.
Okay, bring the signature to the provider.
State of Ohio versus Ashley Hutt, case number CRA 2657.
So do I have to have this printed out?
If you could, yeah. You can get the show, or Sean can print it out, just tell you need it.
Okay, thank you. All right, this is State of Ohio versus Ashley Huff, CRA 2657. Ms. Huff is present with her attorney, Mr. Smith. And she received a very good report today.
Misdemeanor domestic cooking, suspended sentence, probation, pediatric treatment. You're the dude.
Lisa, just treatment, that's it, right?
Yeah, well, you might have to be service. No, I couldn't go to jail or anything. Give me some jail time, suspended. Judge, I think we have a resolution. The state, this is a felony, it's on the felony docket. She's doing well in treatment. Mr. Hill indicated this morning in pretrial discussions that if she were willing to enter a plea to an amended charge of a misdemeanor domestic violence charge, he would recommend 90 days in jail, all of which would be suspended. She'd be placed on probation under such terms as the court believes appropriate, with the specific condition that she successfully complete treatment as a probation requirement. Did I get that right? You weren't listening, were you?
I'm multitasking. Plus I'm still recovering from the near-death experience I just had.
90 days, PDM1, complete treatment for probation, requirement probation, and then whatever terms.
Plead to the M1, 90-day suspended and complete treatment. Yes, I would be very pleased if that happened
Yeah,
today.
you might have to let's pay a fine. You're not going to be incarcerated. And it gets the felony shelter.
All right, Ms. Huff, you've heard what your attorney's represented to the court. Is that what you wish to do today?
That's fine.
All right. Mr. Keel, do you want to make a motion to amend that?
We would make that motion on the condition that she does enter a guilty plea to the misdemeanor.
Well, they're amending it, it's under the CRA 2657. They're gonna amend it to the M1 version, it's still under 2919.25A. All right. Ms. Huff, I will accept you want to enter a guilty plea to the misdemeanor?
Yes, sir.
All right, I'll accept your guilty plea and or guilty finding. It'll be 90 days jail, 90 days suspended. It'll be a $150 fine. I will order you to pay the court costs. There will be a review date for September 21st of 2026. 2 years, level 4 probation.
September. Would you read through?
I'll order 30 hours of community service. And as a condition of your probation, you'll have to complete your treatment with Bethesda.
She'll do that, Judge.
All right, Ms. Huff, you'll need to receive probation before you leave.
Thank you, Your Honor.
Yeah, really, all of a sudden, it's overwhelming.
State of Ohio, we call Tara Stover in Lawrence County Jail, case number CRB 25590. Jeffrey Spencer is on deck.
This is CRB 25590, State of Ohio versus Tara Stover. Ms. Stover is present via Zoom. Mr. Smith is her attorney. And we recalled this to see if hometown would be willing to take Ms.
Judge, you're correct. The officer's order sits today to 180 days in jail or give it a try again. She has assessed for inpatient treatment. I believe is requested GPS given the situation happened prior with Bethesda. I wouldn't argue against that. I just don't know the status of our monitors here, how many we have. But they're willing to take her.
I'm not sure. I believe we do have some residents.
Okay. Mr. Hield, your thoughts? I know you had indicated you were preference would be the sentence today and move on.
I mean, I think she's already burnt all her bridges, but I also want her to get in recovery permanently. But we're not going to forget that she's pled guilty to this and that she's going to owe a pretty good chunk of restitution and that she needs to face some consequences for that. And then to go to Bethesda and then leave, and then the report is that she, slanders them online, libels them online, whatever it is. Not appropriate. So if the court's going to send her there today, that's good, but as far as we're concerned, it's a very short leash.
We could come back in 2 weeks if you want, 30 days, whatever the court or the state feels. As long as she's going to get treatment, I'm okay.
Oh yeah, we need a GPS monitor, right? Is that?
Yes, they requested it.
All right, Ms. Stover, you've heard, did you hear what's been talked about today?
Yes, sir.
All right, I'm going to give you some admonitions before we do anything here today.
I'm sorry?
I'm going to give you some admonitions before we do anything here today. Okay?
Okay.
And other than saying, I understand, I don't want to hear anything from you. You understand?
I understand.
Okay. So you've entered a plea already to this charge. You've got 6 months hanging over your head, potentially, that I can sentence you to. The state wants me to sentence you to all 6 months of that today. And quite frankly, it's probably warranted in this situation. However, I'm willing to give you one more shot at treatment. This is your one shot. Are you willing to go to treatment?
Yes, sir.
Okay. I'm going to allow you to go to treatment, but I'm going to put you on a GPS monitor.
Yes, sir.
So if you leave, we will know that you left. And I can promise you, when you come back before the court, the leash is gone. There's no other thing I can do for you to help you. My only option will be to sentence you at that time. Do you understand?
Yes, sir.
Okay. Now, in addition, if you cut the monitor in this case, if you were to leave and try to tamper with or cut the monitor, you could be charged with tampering with evidence. You could potentially be charged with escape because you've already entered a guilty plea. And both of those are much more serious felony charges. One's a felony of the second degree, one's a felony of the third degree. Up to 8 years in prison on one and up to 3 years on the other. Now, if you cut that monitor and you do that, the court, and it won't be our court, it'll be the common police court, when they hear felony charges, will likely send you to prison for at least 3 years for that. Do you understand?
I understand.
So, I don't want you to leave here today saying, hey, I wasn't warned, hey, I wasn't advised. I want it to be crystal clear that this is your last shot at this, with this court. Do you understand?
I understand, sir.
Okay. So what I'll do is I'm going to, how many days have you been in jail?
County last time and this time?
Just this time?
Since Saturday.
Okay, so you've got 2 days then.
Yeah.
All right, on the failure to appear, I'll sentence you to time served on the failure to appear.
Yes, sir.
I'm going to set you a new bond going forward. It's going to be a 4,000 OR. There's going to be GPS monitoring, and you're only to be released to hometown recovery for treatment.
You want to come back, Your Honor?
Let's come back.
I just need to avoid April 24, 27.
27.
Yeah, those are my 2 bad days.
Let's come back on April 17th,
I can do that.
and I'll set that for sentencing. So, Ms. Stover, you will be released once there's an ankle monitor available. Put that ankle monitor on you. Hometown recovery will then come pick you up.
Yes, sir.
Okay?
Yes, sir.
All right, good luck.
Thank you.
Thank you.
Thank you.
State of Ohio versus Jeffrey Spencer at Lawrence County Jail. Case number CRA 26162, CRB 26163, CRC 26484.
Roger, what's next?
All right, this is State of Ohio versus Jeffrey Spencer, CRA 26162, CRB 26163, TRC 26484. Mr. Spencer's present via Zoom. We can have him assess.
He meets qualifications for inpatient services, and we could pick him up today.
He's willing to go, Judge.
Is that correct, Mr. Spencer? You're willing to do treatment?
Yes, sir. Yes, sir.
All right, I think that is a good move on your part. I will set. I'm going to set bond at 2,000 OR with the condition that you're only to be released to Bethesda for inpatient treatment. And we'll come back April 20th for a pretrial and preliminary hearing at 10 a.m.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Thank you.
Thank you, Mr. Spencer. Good luck.
What's that date again, Your Honor? I'm sorry.
20th.
State of Ohio versus Daniel Doss. Case number TRC 26 483, A, B, C, and D.
Yeah, but I don't have a case number on that one. It's 26 first.
All right, this is State of Ohio versus Daniel Doss, POC 26483. This is Mr. Steyer's case. We were recalling this to see if Mr. Doss needed treatment.
Yes, we will take him, sir.
And is that going to be inpatient?
Well, they will do a more thorough assessment, but
Okay.
more than likely.
Okay, with that in mind, we had set this for May 1, probably want to come back a little sooner instead of sticking with that May 1 date.
Okay.
So,
What would you like?
I'm here the 30th, if we want to just come back in a week and see where he is.
All right, setting back Mr. Doss back on March the 30th. I'm going to give him a $2,000 OR bond release focus for treatment.
Thank you.
All right, thank
Thank
you.
you. Thank you, Your Honor.
Thank you, Mr. Doss.
Your Honor, we'll finish with Lawrence County Judge. State of Ohio versus Ethan Anderson, case number CRA 24706.
And I believe I see Mr. Anderson on the screen, Your
See
Honor.
him on the screen. Mr. Anderson, can you hear me?
Yes, sir.
All right, this is State of Ohio versus Ethan R. Anderson, CRA 24706. This is Mr. Steyer's case. We've got Mr. Anderson present via Zoom today. This matter set as a preliminary hearing. A few minutes.
So at the moment, well, I'll give you a moment to read that. So Mr. Anderson, do you have any indication on when you're going to be coming back to Lawrence County?
What do you mean, like in town?
We don't as of yet.
Okay.
2.5 level of care for the counseling center is in Portsmouth.
Well, that's what I meant. I'm sorry. I just meant the area, I should say then. Do you have any idea when?
I'm in here. I'm in Portsmouth right now.
Oh, I'm sorry. I didn't realize you'd gotten back. I misunderstood the letter. So he's back. So what we need to do at this point, we've been waiting for him to return to the area. I said Lawrence County, I guess he's actually in South County. I hear you, sir. Kind of decide where we are on things. I mean, at this point, we're going to have to give him some time in the treatment program to start getting some information under him and his feet under him and see where we are. So I think we need to continue this again, but I'll leave it to the court's discretion about how far out you want to go.
Okay. Let's do May 1st.
Okay.
And that'll be a preliminary hearing at 10 a.m. Mr. Anderson, keep doing well. I think everyone here wants to see you succeed.
Thanks, man. I appreciate everybody.
Thank you.
Thanks, man. Thank you, everybody.
State of Ohio, Eric Johnson. Case number CRA 2622, CRC 2675, A and D.
All right, this is State of Ohio versus Eric Johnson, PRC 2675, A and B, CRA 2622. This is Mr. Steyer's case, that's a preliminary hearing and a trial.
Your Honor, we have an improperly handling a firearm in a motor vehicle, F5. The basis for that charge is the allegation that he was under the influence of alcohol, a drug of abuse or combination thereof, as well an OVI and a taillight charge. The state, there was a urine screen on this, and the state agreed to keep it here, at least pending the urine screen result. That came back, and Mr. Johnson tested over the legal limit for THC. With that in mind, the state has agreed that if he were to forfeit the gun and plead to the OVI, which is a first offense, no aggravating circumstances, he had proof of financial responsibility, that they would agree to then dismiss the felony charge that's pending. And so with that in mind, we're going to enter a guilty plea to the OVI and the taillight charge that are pending now, and I would expect after that plea is accepted that the state would make its motion to dismiss the felony.
And that is correct, Your Honor. And I don't know, did you mention the forfeiture of the gun?
Hey, I don't know if I did or not, but forfeiture of the gun would be required, and he is agreeable to that.
Is that correct, Mr. Johnson?
Yes, sir.
All right. I'll accept your intentions to enter a guilty plea to the OVI and to the taillight violation. Is that correct?
Yes.
All right. I'll accept your guilty plea to both the charges, and I'll enter a guilty finding on the OVI. I presume that he wants to do the DIP school.
If you intend to do the driver intervention program, that's the 3-day school. By doing that, you avoid jail time.
It's either 3 days in jail or 3 days in DIP school.
I guess I'm going to school with him.
Yeah.
Fair enough. I assume
I've
so.
been to the county, it ain't
I
nice.
assume so, but I wanted to ask. So.
It'd be pretty awful hotel to beat Lawrence County Jail.
All right, so here's what I'll do. On the OBI, I'll sentence you to, it'll be a $500 fine. All we need to pay the court costs. There'll be a license suspension from 180 days from today's date.
And Your Honor, we would seek driving privileges for occupational purposes as well as attends to the DIP school and anything court related.
That'll be granted if you spend any. 20 days in jail, I'll suspend all 20 on condition that you go to the 3-day DIP program. There'll be 30 hours community service, 2 years level 4 probation. Driving privileges will be granted by separate entry.
Oh, yeah, sure. But I don't even know what order videos are supposed to be.
On the B case, it'll be a $20 fine.
Well, I know.
And we'll need to go ahead and put in there, on the A case, on that particular case, we'll need to add in that the firearms to be forfeited for destruction.
And there's a description of the firearm in the complaint.
It's a Marlin.
Yeah, he's got to read it off to her. She's got to type it all in. So he's going to read it a little bit slow to her. I know she ended up taking stuff she didn't pay for. But it ended up just being one thing.
22 millimeter semi-automatic rifle. And that's got serial number 185 503 55.
So you
correct, Your Honor?
Correct. And the CRA 2622 case. We'll give you a review date. CRA 2622.
I don't know, to be honest with you.
And that would be Chris Smith. No, we're just
Get everything finished, take you on probation though. So if you finish everything off, I'll take you on.
I'll give you a review date of September 21st, 2026 at 9 a.m.
If you get everything done before then, you won't have to come back. Nope. But if you don't, you have to be in here to explain why I got it on. They'll discuss that with you when you go out. And speak to the probation officer. I'll pay your best with it. Either to come right here and do it. Because I don't know if you saw it. I saying, oh, look, I'm from Easter. If you come here, you get credit. It's just that camp's never done. It'll be better.
All right, Mr. Johnson, you need to see your probation before you leave.
Thank you, Your Honor.
Thank you.
City of Ohio versus Dolores Hill, case number CRA 26150, CRB 26151, A, B, and C.
All right, this is State of Ohio versus Dolores Hill, CRA 26150, CRB 26151, A, B, and C. Ms. Hill is present with her attorney, Mr. Steyer, trying to set up a pretrial.
I have 1 second, Your Honor. I'm signing some entries.
It's okay, Mr. Steyer, take your time.
Where are you with? Yeah.
But she has been compliant and is very well with the regs.
So, Your Honor, this matter, there is a felony pending. However, the other charges are misdemeanors. It looks like the state, oh no, that's Jasmine, I didn't know that you stand there. Okay. We don't have a definitive statement from the state that they're going to keep the case here forever, but I think, having discussed it this morning, at least for the time being, we're going to keep it here. She has begun treatment with TPC Wellness. We don't have a written report, but I've just been told she is compliant. They've only had her since the 16th. We just wanted to get back here quickly, make sure she was integrating, and she is. So I think probably go a little bit further out this time, but go to a date the court deems appropriate, and we would continue to waive time constraints to accommodate that.
Is that correct?
Yes.
Okay. All right, defendant's request, this matter will be continued to May 1st for a pretrial and preliminary hearing at 10 a.m. And I'll note the defendant's time waiver for the record.
Okay. May 1st.
Thank you. I'll step out and help you with that. Don't do it.
Yeah, I remember. I just didn't have a note.
Thank you, Your Honor.
Thank you, Mr. Steiner.
State of Ohio versus Stephanie Stevenson, case number CRA 25-821. Stephanie Stevenson.
She normally appears via Zoom. She's in treatment, and I want to say she's in Portsmouth, but I wouldn't swear to it.
This is CR 25-821, State of Ohio versus Stephanie Stevenson. Looks like she's OBP.
Where's that?
OBP.
Okay, I was wrong there. But yes, the last couple of times she's been on the TV. I don't know if Bree knows.
We had this case,
I have not heard from her. I didn't have her on the list, but I apologize.
It's a preview.
it looked to me like she was scheduled for April 13th already, and I wondered why she...
That's what I see here. It looks like, I was a date that says April 13th. I just wasn't sure if there was another reason that we were calling it or not.
My guess was going to be that she left treatment.
That was my guess, but I don't know that, and I don't want to throw her under the bus. Maybe it's just a
No,
calendaring error.
She completed OBP and she's doing outpatient.
Okay. Is she compliant?
Yes, the last time I checked, but I have her down for April 13th for her next hearing, so I'm not sure what this is for.
I thought maybe she left treatment, but
Yeah, she completed and she didn't leave treatment.
sounds like a calendaring issue, Judge.
Yeah, not that I know of. She was here for her last hearing via Zoom and she's supposed to be back April 13th.
Okay. Well, so that'll be passed in April 13th.
Thank you, Judge.
Thank you.
Thanks, Bree.
State of Ohio versus Bruce Curry, case number CRB 2680, AP&C, CRB 25-124. Bruce Curry.
All right, this is State of Ohio versus Bruce Curry, CRB 2680, AB&C, CRB 25-124. And it looks like this is Mr. Morford's case. We have Mr. Morford in the courtroom.
He's not there. He's not in the conference room, Judge. Let me look.
Did we ever...
He's down.
Yeah, I've sent him right today.
He was going to go to Columbus and get in treatment.
Mr. Morford, this is Bruce Curry. And it doesn't appear that he's here. I don't know if you have any input as to his whereabouts. We've got a sentencing hearing and we've got a bond up with Mr. Sowers.
In that case,
Yeah, but we had it during the same time.
yeah.
Any input as to where he may be?
I have none, Judge.
Your Honor, he pled to the disorderly conduct, and we still needed to find and get some information from the alleged victim on the criminal damaging. And we've had no luck with that and not been able to contact him. But it also says in my notes that he's going to Columbus and will get into treatment. So, basically what we're left with is, we intended to dismiss the criminal damaging charge today. And he's pled guilty to disorderly conduct, so.
Never got that either.
Why don't we do this? Let's put this on for the 20.
Where a victim wants to press charges, they were supposed to be able to.
Let's put this on for March 30th. Mr. Morford, that'll give you an opportunity to try to get in touch with him. Since the state needs to get restitution numbers anyway, that'll give Mr. Morford an opportunity to reach out to him, and if give the state an opportunity to get restitution, and if not, we'll issue a warrant if he's not here.
Bruce Curry.
Thank you, Judge.
All right, thank you, Mr. Moore.
State of Ohio recalls Jessica Smith, stuck in holding, Your Honor. Case number CRB 2621, CRB 25780.
We could have Mr. Roger Smith in the courtroom.
Did you ask for, stepped out when he's in there.
Your Honor, if I may, stop for you here.
2 violations.
Well, that's the 2 violations, but this is the letter they sent me when she left. We also had her look representing today.
Okay.
And Your Honor, she's been with us since the 6th of this month, so she's been in treatment and she's been doing well. She's been tapering down off of her methadone. She's cut her dose in half. That's her goal. And after she completes OVP, her plan is to continue back to restoring hope.
Where was she prior to OVP?
Restoring hope, Your Honor.
Okay.
And with the drug screen, Your Honor, my recommendation would be to let her go back to OVP. Mr. Smith is not.
If we can get Mr. Smith in here.
Yeah.
He may have left, he may have forgotten about this.
That's on the motion. Okay.
It was an arraignment today.
Still here.
Yeah.
I was in the car answering emails, Judge. Luckily, I had left.
All right, some developments since you were last up here,
Yes.
Mr. Smith. It looks like there were 2 probation violations filed for her leaving, not completing the treatment ordered by the court on both of them, and a drug screen was done. She was negative for all substances other than methadone, which it was indicated she was on methadone and is tapering off.
Oh, okay.
Mr. Major's recommendation, we've not technically done an arraignment on the probation violations, and we'll get to that part here in just a second, but is to allow her to continue and go to OVP, continue to OVP.
I appreciate that.
Mr. Major, are you intending to proceed on the probation violations at this time? You wish to dismiss them?
Just dismiss them, Your Honor, at this time.
Okay. So both probation violations then will be dismissed prior to arraignment, so we won't need to go through the arraignment process on those. And Ms. Smith. On the failure to appear, originally we will call the warrants on those. I'm going to let you remain in treatment at OVP. However, I will advise you, this is not the norm. You don't typically get to pick your treatment. If you're in treatment, you're in treatment, and you don't get to leave because you don't like what they're doing or without permission from the court. So this is your one and only shot at that. I'm going to allow you to go to OVP. If OVP recommends something, you have to do it. And if you were to leave treatment against advice, obviously there will be a warrant that will issue again. But going to another treatment provider will not get you into that treatment provider. Your best hope at that point would be if the court was gracious enough to allow you to go back to OVP a second time, because you don't get to choose somewhere else. Do you understand?
I do understand, Your Honor, and I apologize in the word.
That's okay. Is that crystal clear?
Yes, Your Honor.
Okay. So we'll recall the warrants on that. We'll allow you to go remain in treatment at OVP. And I'm going to set you back
April 24 and 27 are my two bad dates.
for April 20th.
I can do that.
And a lot of that is going to be based upon Ms. Smith, you having a good drug screen.
Thank you.
You're welcome.
I'm really trying. I mess up. Like I said, I apologize in the word.
It's okay. If there's ever an instance, and I'm not saying there's not a situation where you would be able to switch treatment providers, but if there's ever a certain situation that arises, you need to call it to your attorney's attention and let him call it to the court's attention, and then we'll figure it out at that point.
Okay.
So you don't need to leave, go check yourself in somewhere else. Request from your attorney and request that from the court, and then we can hear it here properly.
Sorry, I understand that all right. Thank you, Your Honor.
Okay. All right, we'll see you back, Ms. Smith, on April 20th for pre-trial.
Thank you.
Thank you, Judge. Appreciate it.
State of Ohio versus Stephanie and Taylor, case number CRB 25760.
Is this the trial?
This is the trial.
Let's take a brief recess right before the trial. We're just going to take a quick recess right before we have this trial. Of course, we'll recess.